Hey everybody, News Now Wyoming here, bringing you another episode. This is going to be part 4 of the Auditors versus Salvaggio and Leon Valley series. So, if as a rehash of things that have come before this case arises from 2018. Over a period of 3 days, Chief Salvaggio had a lot of auditors arrested, their equipment seized as evidence, and the underlying charge that he had them arrested for on the 3rd day was one of the viewers of the live stream made threatening remarks about Chief Salvaggio. So Salvaggio took that as a probable cause to arrest the person that was streaming, and then everybody else that was around as witnesses, and that's why he was able to recover everybody's cell phones, because they witnessed this crime of somebody anonymously saying violent acts against the chief of police. And so that is the underlying cause of this. And this is the response. So I do want to note that this case was filed in 2018, and this was filed 1/5/2021. Why is that? Well, so the defense, the police chief, went on the stand and said, hey, these people, this should be continued because they are still under investigation. There are going to be federal crimes that are charged in relation to this, so this federal lawsuit should not proceed. Finally, after 2 years of stalls, the court finally said, you know what? This just needs to proceed, because none of that turned out to be true. All criminal charges against everybody besides one who pled guilty to, I can't remember what charges, they all were dismissed by the prosecutor, mainly due to lack of evidence, lack of probable cause, and but it is important to note that a lot of those cameras are still being held by the police department. So even though all criminal proceedings have ended, they are still holding on to people's personal equipment. It blows my mind. I mean, you can go on to Freeman's channel and watch him. You can go on to Justin Pulliam. All these channels, there's a lot of channels that provided the actual video. I don't think I've ever shown more than a couple seconds of it on my channel, but it is pretty horrific. Just the balls on this police chief, and the fact that he still has a job. As of right now, he has a job. He has put in a demand letter for what he is wanting from Leon Valley and he will resign. But he wants money for that. We don't know the details of what he is asking for, but they took no action. They did not turn down his offer of resignation. In my humble opinion, what they did was turn around and say, no, you are a at-will employee, and this is unacceptable to us. So, but the city council cannot fire him. Only the city managers can do that. Okay, so all the officers. Plaintiff's second amended complaint fails to state a cause of action against these defendants upon which relief may be granted. Arises from violations of 1983 and as alleged in plaintiff's second amended complaint. However, defendants deny that any cause of action exists thereunder. They deny the introduction of paragraphs 1 through 17 of plaintiff's second amended complaint. And I did not actually do a video on the second amended complaint. Looking at it, it's pretty identical to what I've already done a video on, except they added on the prosecutors, which in a previous video I explained why I believe the prosecutor's case is going to be dismissed due to prosecutorial immunity. Their mendacious allegations of conspiracy among law enforcement and the DA's office is without merit. They deny the introduction paragraphs, which show unto the court that the plaintiffs are not law-abiding citizens, but rather zealots who attempt to provoke law enforcement. Now, I do want you to make sure it's clear. It is not against the law to provoke law enforcement. The fact that the police chief has such puny, tiny feelings that somebody can point a camera at them and he's like, oh, the crime, the horror, this is horrible. That does not make it a criminal defense or a criminal charge. All right? They did nothing illegal. They did nothing that was considered bad. Yes, they provoke police officers, but why are those police officers allowed to be provoked? I don't care what they said. That's your First Amendment, right? You could tell a police officer whatever the hell you want. Police officer does not have to respond. In fact, the fighting doctrine that is for normal citizens, if you were to come up to me and say something about my mom, I could use the fighting doctrine, or police could charge you with the crime because the words you used fall under that fighting words doctrine. Wyoming has it. However, courts have routinely held that police are held to a higher standard, that the fighting doctrine words does not apply to them. That they are trained and expect to behave better than the normal citizen does. Admit paragraphs 37 through 57 are properly named. They deny where plaintiffs allege that defendants' actions were unconstitutional. Defendants deny allegations of deliberate indifference, reckless disregard, and intentional conduct. Put this on highlight. As alleged in their second amended complaint, which show to the court that Mark Brown was arrested for interference with public duties and resisting arrest. So, interference with public duties is a very clear charge. And let's see if I can find it really quick. And A, a person who commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with a peace officer while he is performing his duties. A person who is employed to provide emergency medical services, a firefighter, so it's going to fall under A1. It's a Class B misdemeanor. It is a defense that the conduct engaged was intended to warn a person operating. It is a defense under the prosecution that the interruption consists of speech only. Now, did he physically put himself in front of the cops? The videos don't show that. There were lots of people with cameras on site, and none of them showed him physically impeding. Now, did he resist after they placed him under an unlawful arrest? Possibly. Okay. Yeah. But interference with public duties? No. Defense deny allegations that detentions and arrests were made without lawful basis, which show that David Bailey was arrested for obstructing a passageway. He was standing in the door that nobody was trying to enter, and when they said get out of the way, he stepped out of the way of where people would walk. So when they warned him, he got out of the way, and that's clear again in the video. He was James Freeman was arrested for interference with public duties. Again, words only. All detentions and arrests were lawful based on probable cause. Subjected to excessive force as alleged, they would show to the court that they are entitled to protective shroud, quality immunity, and official immunity from all plaintiff's claims. So and notice that in this motion, This is all the police officers. This is not the prosecutors. They've already filed their own motion, which has a better chance of winning. Showing to the court that the plaintiffs are a cabal. You are a cabal of communication zealots. Come on, I've turned on. Intent on bringing chaos and disruption to municipal governments, and in particular the city of Leon Valley. Plaintiffs and their cohorts, through live feeds on social media instigation, yes, conducted mass phone callings to city offices and mass email communications to city of Leon Valley offices to disrupt the government of the city of Leon Valley. Now, every single one of these live streamers and YouTubers say, if you feel you have a grievance against your government, here is the phone number you can call, which is a constitutionally protected right. You can file grievances against your government, right? That's a First Amendment right. That is a clear and established First Amendment right. Now, it's not clear that they can have other people do it, but they could say, if you feel you have a grievance, you may call them. Contrary to their alleged self-imposed title of First Amendment auditors, plaintiffs are churlish fomenters. I need to look that up. Churlish definition. Rude in a mean-spirited and surly way. And fomenters. Instigate or stir up. So instigate in a rude and mean-spirited or surly way. Okay? I'm not going to deny that. Again, where's the crime? Tell me where the crime is. If there's a crime, make sure it's clear. There is no crime in that. They're assholes. Most of them are. Okay, I've criticized James Freeman on my channel. If you look at the video I did on his, right? He was very provocative, beyond the pale, extremely illegal. You don't have to treat cops with respect. That is not a law. Defendants assert unto the court that plaintiffs' rights under the First and Fourth Amendments were violated, and they were not subjected to excessive force. So at all times made the basis, they were in the course and scope of their employment as City of Leon Valley police officers and peace officers of the state of Texas, acting pursuant to in their discretionary capacity at all times, acted in good faith, and thereof are entitled to protective shroud of qualified immunity. Well, that's not the whole shroud of qualified immunity, right? You guys, there's clear evidence that most of what you did was clearly established that what you did was bad. They more deny, deny, So I'm not going to read each of these, you guys. Deny. All the counts that are in the amended complaint are denied. Denied. Okay, let's get through all this. Ooh, deny. Monell paragraphs. Defense would show. So the city is not party to this motion. So why is defense would show unto the court that plaintiffs have failed to state a Monell liability claim under 1983 as a matter of law? Defense would further show unto the court that all defendant officers were trained in accordance with the Texas Commission on Law Enforcement and maintain in-service training in accordance with state standards. They have failed to state a cause of action as a matter of law. And here again, I think Monell is easily met because the police chief, who is their boss, says everything that they do is okay. By a matter of policy, what they did was okay. It was good. By the training that he provides them, he says what they did was good. You can review the video evidence and judge for yourself if you think a reasonable officer would behave as they did. And I would contend to you that hell no, they would not. No part of what they've done. Now, one of the things that really pissed them off, I can't remember which day it was, but I think it was the second day that they were out there. They went into the atrium entryway of the municipal building, and then they had a Blue Lives Matter flag, you know, the blue line cross, blue line, yeah, I mean, I would call it a cross. There's the cop sanctuary flag that they've got, and they stepped all over it. And the cops got pissed. You can see in the video. Oh, it was hilarious. Again, legal, as long as it was their flag and not property of the police department, which they've never alleged. So I'm going to assume it was purchased by one of the auditors. Affirmatively plead both prongs of qualified immunity analysis as a defense in the case at bar. Their conduct did not violate a constitutional right, and further assert that their conduct was objectively reasonable in light of clearly established law. I would argue that over and over and over again. But I disagree with that. Against the Texas Tort Claims Act, once again, they're going to use the Texas Tort Claims Act. And I can't remember what all claims were brought, which would have been Texas state or federal. But this Texas Tort Claims Act is very broad in its immunity given to police officers acting under the authority of state law. So if there were any state claims brought against the officers, yes, I would agree that they would be dismissed. I despise that, but under clear Texas law, I would agree with that assertion. I would not agree with that under any of the 1983 claims, though. Prayer for relief. They deny plaintiffs are entitled to any punitive damages as alleged. They deny that they are entitled to any injunctive relief, or that they are entitled to attorney's fees as a matter of law. Deny any allegations in the Second Amendment complaint not specifically admitted herein, and demand strict proof thereof as required by law. Herein demand a jury trial. The stupid officers pray that plaintiffs' suit be dismissed against them, or in the alternative, that plaintiffs take nothing by their lawsuit against them, and defendants have judgment herein, that the defendants be awarded their costs expended, including reasonable attorney fees, and for such other and further relief, both general and special, at law and in equity, to which they may show themselves justly entitled. Signed by the attorney for all the stupid officers. Alright, so this was filed 2.5 years after the original suit was filed. The case was put on hold for over 2 years because of Chief Salvaggio lying on the stand and making representations that were clear lies. And Chief Salvaggio, as of the moment of this video, was still employed by Leon Valley. So, yeah, take that what you will. Thank you guys for joining me. Make sure you hit like, subscribe, write in your comments what you think about this motion to was it just a reply, or no? There wasn't a motion, so it was just their reply. First Amendment answer according to the Second Amendment complaint. So let me know what you think about this complaint. Let me know what you think of the case in general. Alright, you guys have a great day and have a good one.